Appeals, Miller and others, and O'Brien and the Ministry of Justice, and Walker and Innospec. Yes.
Good morning, my lady. Good morning, my lords. As you know, I appear for Mr. O'Brien and what are known as the Miller appellants. We are somewhat more-handed as counsel. I think there are 12 in court and not quite up to the other Miller standards.
Nearly.
But
But the gender balance is rather more satisfactory.
I hope that is being noticed given the day. But perhaps I can just introduce counsel very shortly. My team here is Rachel Krasnow and Tamar Burton. On the left is Rachel Cam, John Kavanagh and Charles Bourne. And then over here we have Nicholas Randall and Claire Darwin. And somewhere is Jason Coppell and Holly Stout.
Over there.
Over there. And Martin Chamberlain and Max Schaefer over here. You have, I think, actually got a list of counsel already in the note prepared by the registry, but it's on our speaking note, which is in front of you. I have until 12:40 this morning, and I've got an awful lot of ground to cover. And so what I've done is try and reduce these submissions to a speaking note. I will take this as quickly as it possibly can for the obvious reasons, but the idea of the speaking note is so that you will perhaps be able to go through with my submissions without necessarily having to take a note of everything as we go through.
And the speaking note is this outline of oral submissions, is that right?
That is right, yeah. I'd forgotten that's how I'd called it at the beginning. It's not a full speaking note, but it's there to assist the court and to make sure we get through it quickly. Now, I apologise in advance that does mean I shall read some of this to you. When I do, I shall probably read it fairly quickly, but if that's a problem, please say so, as I'm sure you will. The court will know the appeals concern 2 points, the so-called year 2000 point and the primary time limit point. They both follow on from this court's judgment in O'Brien in 2013. The reference is in paragraph 1. And we've noted that judgment in our case at paragraph 2. Lady Hale will recall that she and Lord Hope gave the judgment in that case, holding that there'd been a breach of the Part-Time Workers Directive in denying Mr. O'Brien, a retired part-time recorder, a pro rata equal pension to a retired full-time circuit judge. And they concluded that judgment, as we've set out in the box, the reference is there. For these reasons, the appeal is allowed. The case will be remitted to the Employment Tribunal for the determination of the amount of pension to which Mr. O'Brien is entitled under the 2000 regulations. Those were the part-time workers regulations made to transpose the Part-Time Workers Directive in accordance with this judgment. And that judgment, as you will appreciate, gave rise to similar claims by many, many part-time judges all across the spectrum of the judiciary. The judicial posts of the appellants in Miller are set out in the appendix to the SFI, and I'm going to ask you to just pull that up for a moment. The electronic page is 2311, and that happily is also the page in the core bundle. As a matter of courtesy, can I say if I give that the right, 2311? Yeah. I should correct an error, or two errors, I think. We have in court Peter Hayworth, John Sprack and Charles Fox. Peter Wayne is not here. And the first two have pointed out that I've made a slight error in that Mr. Hayworth, and you might like to note this somewhere, became a deputy district judge in 1992 and is continuing. And Mr. Sprack became a fee-paid employment judge from the 1st of February 2002, I think I put 4 there, and retired in April 2013. It's a small comment, but Mr. Fox initially was in something called the Supplementary Disability appeals tribunal, which morphed into becoming the first-tier tribunal social entitlement chamber. Small points, but important perhaps for accuracy. Now, in paragraph 5, under the heading, the conditionality of the JPA and the JPRA, up until the point of the court's judgment in O'Brien in the Supreme Court in 2001, the MOJ and its predecessors had not raised the shadow of an argument that if Mr. O'Brien succeeded, his pension should only be based on service from the due date for transposition of the Part-Time Workers Directive. Indeed, the judgment of the CJEU on the reference in this case had established that a principle of European law, which is not, as far as we are aware, a principle of domestic law, the future effects principle, applied generally to the Part-Time Workers Directive, suggesting the complete opposite of the submission which is successful in the Court of Appeal and which I have to challenge before you today. Rather, the first time that Mr. O'Brien's case came before the court, it concerned only the interrelationship of 4 matters. Firstly, circuit judges were entitled on retirement to a pension by reason of either the JPA or the JPRA, which we'll look at in a moment. Recorders do the same work as circuit judges, but are not similarly entitled by statute to a pension. The Part-Time Workers Directive imposed an obligation on member states to outlaw part-time worker discrimination. And although the part-time worker regulations were made to transpose the directive, they were written expressly so as not to apply to fee-paid judges. See Regulation 17, which was discussed at great length in the first time round in the Supreme Court. The reference is there if you need to see it. The question, therefore, was whether Mr. O'Brien could rely on the directive to trump the PTWR Regulation 17 and to force the PTWR to be construed and applied to assist him, so as to establish that he had a right to an equal pension pro rata to a circuit judge. And the answer, as we know, was yes. That litigation did not require very detailed knowledge of the relevant statutory provisions for judges' pensions. It was enough to assert that they existed. This stage does require a somewhat more detailed knowledge, albeit we don't need to go through every statutory provision for employment judges and so on. We just need to show you the framework for that. And we've referred to these in our cases at core volume, MS 23220 at 32 through to 37. The relevant legislative text of the JPRA is in a supplementary bundle. The reason for that is that although a provision of it is in the electronic bundle, it's not the right date that has been put in because the Act has been amended. So if you don't mind pulling out the black volume that was sent through yesterday, and which I see some, and I hope all of the justices have got a copy of, I will take you to it.
All of this can be filed electronically in due course, Mr. Allen.
Of course it can, yes.
Including
And you will see that it has got consecutive electronic numbering. I'm afraid we picked up the point that the wrong page had been put in the previous bundles in the course of this week when preparing for trial. Now, I'm going to, if I may, take a moment to take you through this. And I do pause for a second to say, this, of course, is the JPRA, which came into effect in 1993, or the beginning of 1994, and it didn't entirely supersede the JPA of 1981, which may well apply to some of the justices on the bench. But it gave an option that you could choose whether you took your pension under which of the two acts. So this is the latest version, but it's sufficient for my purposes to take this. This part applies to any person who first holds qualifying judicial office on or after the appointed day. To any person who immediately before the appointed day was holding any qualifying judicial office, service in which was in his case subject to a judicial pension scheme, that would be the 1981 people, and who on or after that day ceases to hold that office is appointed to some other qualifying judicial office. And I can read straight on, and you can see the election provision in 1D, but I don't need to read that.
Can I just ask, Mr. Allen, we're looking at a version which was in force until 2008.
This is because Mr. O'Brien retired in 2005. Yeah. 2, any person who holds qualified judicial office on the appointed day and who held such an office at any time before that day shall be entitled in such circumstances to make an election, and we don't need to go through that. But if I can take you on to sub 2, which is at page 3423, the entitlement is set out. And this is key because it's a clear set of statutory conditions for a payment by the government to a retired judge. Any person to whom this part applies who retires from qualifying judicial office on or after the day on which he attains the age of 65, and who has at the time of that retirement completed in the aggregate at least 5 years' service in qualifying judicial office, shall be entitled during his life to a pension at the appropriate annual rate. And then there are alternative provisions in 2 and in 3 dealing with early and medical retirement, which I don't need to read because they don't apply to Mr. O'Brien, and removal from office. And then over the page, if you could just pick up at 7, sub 7, as far as a judge who falls within the qualifying judicial office provision, in determining the length of a person's period of service in any qualifying judicial office, it's immaterial whether he works full-time or part-time, but if he holds 2 or more qualifying judicial offices concurrently, no day shall be counted more than once. So that deals with overlapping appointments. And then if you'll turn forward to 3427, you'll see the class of judge within the scope of the provision. And I'm glad to say that you all are, but equally, circuit judges are, as you will see, who was the comparator for Mr. O'Brien. Now, there are cognate provisions in relation to employment judges and so on, which really essentially mirror this and which we've not burdened you with at this stage because it's not necessary for you to do so, and it's not suggested that it's necessary for you to look at those. In fact, you can find also, for circuit judges, a rather more detailed summary of this in the core volume at MS 2444. In the judgment of E.T. Judge Macmillan.
Can you give me the page again?
2 and then 3 fours. And it's paragraph 13.
Mr. Allen, could you also give me the, I'm not sure that they're numbered, the tab number? I think it's 5, isn't it?
It's under the tab marked appendix on my volume.
I haven't got the core volume with me because
sorry.
I always rely on the electronic bundle, but the electronic bundle isn't working. So you're going to have to be tremendously helpful.
Right. Would it be helpful to offer you a memory stick with it on?
It's going to take me some time. So I need to listen to Mr. Allen while I'm doing
Yes.
Yes.
My lady, we do have a thumb drive we could offer you, I think.
Yeah, I've got a spare one.
If that would help, and then you could just open the thumb drive.
That would be very...
Give you my friend's copy of the hard copy of the
I don't want that, thank you.
Inundate.
I think you want it electronically, don't you?
I'd love to have the...
The thumb drive is coming forward.
Yes.
I'll wait a moment while you open it.
It's all right, carry on.
Right. Well, you can see, I'm not going to read all this out, but I do want to draw it to your attention because there's a more detailed description of the conditions for the 2 schemes that E.J. Macmillan set out in his judgment from paragraph 13 essentially through to paragraph 16, and that may be helpful for your judgments in due course. As I say in my note at paragraph 10, no one has ever suggested this summary is wrong, and we've also set out more detailed submissions in the skeleton in the core volume at 2840 to 2843. We also set out what we said was necessary for comparable treatment in our submissions to the Court of Appeal. I've said we'll look summarily at this. I don't think I'm going to have time to do that, but the reference is there for you. Our submissions on the statutory conditions that have to be met for the complete entitlement to a judicial pension have never been the subject of any riposte from the Ministry of Justice. But we do set them out clearly in a moment to make this point rather more relevant to you. Now, turning to the MOJ's basic argument against us, their primary argument is rather that periods of service before the transposition date of the Part-Time Workers Directive are, as a matter of settled European jurisprudence, irrelevant for quantification purposes following your judgment in 2013. And they say this because they submit, as Lord Justice Lewison held and the other members of the Court of Appeal agreed, there's a rule of law of universal application to the effect that wherever pension rights are claimed by reference to European law, and this is it in the box, the legal situation in relation to pensions is definitively fixed on expiry of a period of service. So, after 1 week, your pension for that week is fixed. The next week, it's fixed again. Next week, it's fixed again, and so on. Week by week, it's fixed. That's their case. And that is the MOJ's case in a nutshell on both appeals. And it's that we will have to engage with, particularly in the submissions that we make. The general ripostes. By contrast, it has been constantly submitted for Mr. O'Brien that the relevant phrase is not actually definitively fixed, but permanently fixed, and I'll show you that phrase in a moment, and that the entitlement to a judicial pension only becomes permanently fixed upon retirement. There's a very useful bit of jurisprudence that deals with this, which I shall turn to in a moment, in an opinion of Advocate General Cosmos. It's adverted to, but not, we say, properly engaged with in the submissions, in the judgment of the Court of Appeal.
Can I just ask, when you say there that entitlement becomes permanently fixed on retirement, are you dealing with both qualification for a pension and also how the pension is quantified?
Qualification for a pension is a qualification which is contingent until all the conditions are met. So while that's a distinction my friend makes, it's not a distinction that we make on the application of the Part-Time Workers Directive. And that point will come through, I think, as I go through these submissions in greater detail. In short, and I'm running ahead of myself, if I can go, I'll come back to AG Cosmos in a moment, but if you can pick up 17, you'll see how we put it. In short, it's submitted that the pension entitlement is not permanently fixed before retirement. Indeed, determining whether or not a judge has a fixed permanent right to a pension is a subject to multiple conditions. The precise conditionality for a judge of a judicial pension under the JPA or the JPRA is the fact of retirement. If the judge dies before retirement, there ain't no entitlement to that judge to a pension. There may be spouses' entitlements that arise, but the judge himself gets no pension. The judge has to be alive and has to be age 65 or 65 plus. And you've seen that in the section in the JPR in subsection in section 2. They have to have fulfilled the minimum time in judicial office for the JPRA, which was the 5 years, which I've read to you. There has to be a final salary. So you have to work out what the final salary is, and where applicable, there has to be an election as to the JPA or the JPRA as to the basis of the basis of the pension. So we say that the actual entitlement, you can't answer the question, what pension, are you entitled to a pension as of today, and in what amount, until those conditions are all met. And that's why we say the importance of looking at the detail of the actual legislation to determine when the right to a pension is permanently fixed is obvious if the court reflects on the fact that the rights in the JPA have themselves been altered over time. So the statutory framework may alter. When a judge starts in their career, you don't know exactly what the pension will be because you don't know what the prevailing judicial pension scheme will be at the time. And that's certainly a point that many judges at the moment know all too well who've been litigating precisely this way. In short, how the judge's career relates to the terms of the legislation are what determines whether his or her rights are permanently fixed. The MOJ's argument does not engage with this because what they say, picking up Lord Reed's point, is that the question is predetermined on the day that you do the work. We say you can't work out what the significance of that day is until the point of retirement. Now, I said I would show you Advocate General Cosmos's jurisprudence on that. It is in a case called Anderson, which is at Volume 4, Tab 57, MS 1359. I'm going to suggest, I want to give you that reference, but you can find it all fully set out in rather better detail in our note to the Court of Appeal on this, which was appended to our case to this court, which is at MS 2344 to 2352. And if the court could go to that, I'll take you to the points quite shortly there. If you have the paper copy of the bundle, you might wish to put in a marginal note to the reference to Anderson, which is Volume 4, Tab 57, at 1359.
It's at the bottom. You've done that.
It's already been added. I'm so sorry, in the footnote. And you'll see that in this case, Advocate General Cosmos was examining on a general basis the interrelationship between what we've called the FEP and the general European law principle of legal certainty, which very largely mirrors ours, but not entirely. The analysis of how the concept of a legal situation becomes permanently fixed was set out in his opinion, and which we've set out in the box, and I'll take you through it fairly shortly. I think it's necessary in this regard to clarify certain points regarding the temporal effect of a rule. He meant by that a legislative rule. First of all, there must be no confusion between the retroactive effect and the immediate effect of the rule. In order to distinguish between them, regard must be had to the temporal aspects of the situations governed by the rule. Retroactive effect consists in the application of the rule to situations which were permanently fixed before that rule came into force. Immediate effect, which in principle works likewise according to the principle tempus regit actum, consists in applying the rule to situations which are continuing. This means that the temporal scope of a rule, which includes the future effects of ongoing situations which were created but not permanently fixed before the rule entered into force. Now you can see the significance of that for our argument. In short, Mr. O'Brien had not retired at the point that the Part-Time Workers Directive gave him the right to equal treatment. His work was continuing. And it is only at the end of it continuing that one then looks and applies the Part-Time Workers Directive and applies it to the JPA or the JPRA, according to whichever he might elect to choose from. I read on. Secondly, it's very important in each case to identify the point in time when a legal situation becomes permanently fixed, because that's the criterion for choosing the rule of law applicable. It is quite useful here to examine the temporal aspects of legal situations, and in particular to draw a distinction between temporary situations and ongoing situations. The first case, the situation rises and becomes fixed at the same time, which makes it easier to determine the rule applicable. In the second case, there's a certain interval between the point at which the situation arises and the point at which it becomes fixed. In that interval, amendments may be made to positive law, as indeed they were in this case. The JPA and the JPR would have affected the comparable circuit judge, as I've said. In that interval, in any event, what matters, as I said earlier, is to identify the rule in force at the time when the legal situation becomes fixed. We think that's a very apt and very neat way of putting the point. Now, the Advocate General gave 4 examples from judgments of the ECJ to show how a legal situation becomes permanently fixed. And we've set out those situations, the paragraph that follows. Is it an imposition to ask the court to read that at its leisure and simply to highlight the point that we say is important? I'm sure the court will want to do that, but I don't really think it's appropriate to take all the time up to do that. Paragraph 61 takes this through at some length, and then if you'll pick up, you'll see we've put something in bold just before that, a few lines. The legal situation which arises from an individual's affiliation to a social security scheme, employment or residence, with respect to the entitlement to social security benefits which it creates, is permanently fixed upon fulfilment of the conditions for confirming that entitlement, or if appropriate, upon presentation of the relevant application by the person concerned. And Mr. O'Brien never made a claim for a pension until the date of his retirement. That's when he applied for it and said he should be treated equally. Now, we've developed those submissions in the paragraphs that follow because we pick up on the cases to which he's referred. And as I say, we invite the court to note those and at its greater leisure to take time to read those. So that's the passage from A.G. Cosmas. Now, the Court of Appeal essentially noted the principle, but they went off on the basis that, as I say, it had been determined that the entitlement to a pension was fully determined on the expiry of the period of service, as we've set out in the box. And our attack on that will be developed later on in my submissions in a moment. At 21, we just outline how the situation in Miller is a little bit different before we get into the route map of those submissions through what we say about the jurisprudence upon which the Court of Appeal and the MOJ have relied for the submission and conclusion, which is under attack in this appeal. Our case is maintained in relation, this is 21, in relation to the Miller appellants for a further and additional reason. This is that Regulation 8 of the Part-Time Workers Regulations makes it clear that where the discrimination is an omission, it continues until that omission stops. And we've set this out in our case, core volume MS 2340 to 2341. And if the court will pick that up shortly, we can just pick up the point there because we set out regulation there conveniently for the court. So that's 2340. You'll see there, Regulation 8 is set out in the paragraph in a box at 119. And you can see where the term of a contract is less favourable, that treatment to be treated is taking place on each day of the period for which the period is unlawful. And if I just read it from the top, I'm sorry, an employment tribunal shall not consider a complaint under this regulation unless it's presented before the end of the period of 3 months, beginning with the date of the less favourable treatment or detriment to which the complaint relates, or where an act or failure to act is a part of a series of similar acts or failures comprising the less favourable treatment or detriment, the last of them. And for the purposes of calculating the date of the less favourable treatment, it goes on during the duration of the contract. And where a worker presents a complaint under this regulation, it's for the employer to identify the ground, and so on. And so, if we pick it up at 120, the Miller appellants submit that it's wholly inconsistent with Regulation 8 to conclude they didn't suffer ongoing less favourable treatment or detriment after they'd ceased to be part-time and upon retirement. There's nothing in the text of the regulation which limits the point of less favourable treatment or detriment to a period within the time when the work was done. And 122, it's long been realised that discriminatory acts can occur at a time post-dating the point when a person ceased to have an obligation to work. It was so held in Rhys-Harper, and indeed a similar approach was taken in Rostock and against Jessamy, construing provisions of the Equality Act 2010, and there's no logical basis to hold that the PTWR, the part-time workers regulations, are an exception. We dealt with this again shortly in the speaking note at 21 and 22. And we might just add that there's a useful case which at least gives an indication of the way things go, called Barclays Bank against Kapoor, which is a House of Lords case. It's at MS 637, Volume 2, Tab 30. I don't say it's dispositive, but it certainly gives an indication of the way these issues might be dealt with. And I'll just pick up the case for you, tab 30. You'll see from the headnote, if I take it very quickly, that this concerned some Barclays Bank employees who were working initially in East Africa, and then I think it was after the Idi Amin expelled the Asians, they came to Great Britain and worked for Barclays Bank. And now I say Barclays Bank, they were different parts of Barclays Bank. But then if you go through it, came to the UK in the early 1970s, it became employees of predecessors of the Respondents Bank. In all cases, the bank had refused to take the applicant's previous service with the East African banks into account in computing their pension entitlement under the bank's pension scheme. In October 1987, the applicants complained to an industrial tribunal that this was race discrimination, that the bank had unlawfully discriminated them, and they'd failed to credit their previous service in computing their pension entitlement, whereas employees of European origin who joined the bank at about the same time had been so credited. The bank contended that the complaints were time-barred by reason of section 68.1 and 7c. And you can see 68.1 at page, on the internal numbering of the report at 366. It's MS 648. And I invite you to just have a quick look at that. It's very similar, not quite identical to the part-time workers regulations. Do you have it at letter E?
Could you give me the page number again?
MS 648.
Thank you.
And then if you'll go back to the headnote at page MS 638, dismissing the appeal that the matter of which the applicants complained, namely that in deciding not to credit them with their previous service, the bank had not employed them on as favourable terms as their European comparators, could not be classified as a deliberate omission within section 68. Rather, it was classified within 68.7b as an act extending over a period, i.e. the length of the applicant's employment with the bank, and accordingly the applicant's complaints were not time-barred. And you can see the discussion of that on the last page of the judgment, the conclusion of Lord Griffiths at 651D, MS 651, internal 369 at D. Now, as I say, we don't say that that is entirely dispositive, but it certainly shows that in that case, the House of Lords did not take the approach that the pension entitlement ended when they moved from the East African branch of the bank and moved into employment in London or elsewhere in Great Britain.
Or was that point raised at all?
That's precisely what the point was, my lord. The point in the case was that they should have brought their claim on coming to Great Britain. That's the point of the time. That's exactly the point. So the House of Lords rejected that and said, no, it continues through your employment. Now, as I say, it's not dispositive because, of course, some of the Miller appellants have completely retired, not all of them, as we've shown through the facts. But as I've also shown to you, others of them remain fully in the service of the state, albeit not on the same contracts, or rather the same terms of service, because it's an office, or at least it's argued by the MOJ that it's an office rather than a contract of employment. As I say, not dispositive, but it's certainly a helpful indication as to the proper approach when you've got discrimination that's happening in an earlier contractual situation, and then you've got a new contractual situation that arises. When do you bring the complaint? Now, I then go to the heading route map through the oral submissions on the case law relevant to the Ministry of Justice Central Submission. In oral submissions, the core point that I've got to address is the Ministry of Justice assertion that was dispositive in the Court of Appeal. And as to this, we make 8 points in response. What I propose to do is to go through those points in summary form, but then I'll open some cases with you, and you'll therefore see what I'm doing and how I'm doing it. The first is that the Ministry of Justice submission derives from the European Court of Justice's exceptional temporal limitation of its judgment in Barber. That judgment held that the equal treatment rule in Article 119, that was the original equal treatment rule in the Treaty of Rome, outlawed differential pension ages contrary to what had been previously thought. The temporal limitation of its application was based solely on the court's recognition of an imperative need to prevent what would otherwise have been a financial calamity for pensions institutions.
Isn't this the essential dispute between you?
Yes.
The respondents in all cases say that's the rule, and that therefore applies generally. You say, no, that's an exception to the rule.
Exactly so, my lady. And these 8 points, as you will see, set out how we make our argument about that, and then we'll have to open the cases. So that is entirely
Is it
correct.
principally Barber or ten other?
This is, no, my lord, the starting
Which
point
is
is
it?
Barber.
Is it?
It is Barber, and I'll show that in a moment.
All right.
The imperative need, as I say, to what would otherwise have been a financial calamity for pensions institutions. The phrasing of the rule, or that should be the paragraph perhaps of the court's judgment, and its basis was somewhat ambiguous. And I will show that paragraph in a moment, if you'll just hold that thought. The rule on which Lord Justice Lewison founded in this case was established by the ECJ in tenova. You could add in there, but I will show you that. For clear purposes, there are 2 of them, and they essentially work together to forward the court's purposes in Barber, and thus to prevent the undermining of the protection from financial catastrophe that the court had determined in Barber was necessary, and, it must be recalled, to give effect to the political will expressed in the Barber Protocol. Before the tenova cases, the Maastricht Treaty had included a protocol, which is the so-called Barber Protocol. Thirdly, we say the rule is not universal. The jurisprudence setting out the rule must be teleologically, i.e. purposively construed, and applied. And as it was established for those purposes, it's limited to those cases and those situations where the Barber limitation might otherwise be undermined. We next make the negative point that there is no European jurisprudence to the effect that it should be applied universally and outside the Barber context, let alone to the Part-Time Workers Directive. Further reason why its application should be constrained is that while it's accepted that the rule is functional for those purposes, it is otherwise contrary to the reality of complaints about pension inequalities. Now, I'll show you that that is the submission of the European Commission when we go through the jurisprudence. But there's a very neat way this was put by Employment Judge Neal in a case called Wright, which I'm going to pick up very shortly at the moment, which is at MS 1088, Volume 3, at tab 45. Incidentally, before anybody asks, this judgment has never been appealed. So, as far as I'm aware, so Mr. Wright.
It was appealed.
Oh, I'm told that it's been adjourned, sine die, or stayed. I beg your pardon, I've overstated it. This was a case brought by Mr. Wright, who was a immigration adjudicator. There were agreed primary facts, which you can find at 1078. The essential point that the judge had to determine was whether the claim was brought out of time. I'll just take you through the facts. He was a solicitor. He was appointed an adjudicator in March 1992, became a full-timer after the transposition date for the Part-Time Workers Directive on the 15th of December. Paragraph 4, did what immigration judges do. His sitting requirement is set out. The number of dates that he has sat on and so on are set out in paragraph 8. And then at 9, the interrelationship between the Judicial Pensions Retirement Act, the Judicial Pensions Act, and the pensions provisions for full-time judges under the Immigration Act is set out, but we don't need to worry about that. Part-time workers regulations are referred to in 10. Regulation 17 was then set out. And then the nub of the complaint starts in 13. In anticipation of the claimant's retirement, on the 15th of October, the respondent, on the 23rd of August, set out the claimant's entitlement in relation to his judicial pension and associated benefits. It was said to be provisional, amounts mentioned have been confirmed, and calculated on the retirement, he would have been entitled to various sums, and the last sentence is critical. The pension is therefore calculated on the footing that the claimant had been in pensionable service only from the 15th of December 2000 to the 15th of October 2007. The pursuing inquiries into further detail of the calculation, there were various points that were made, and then the question for the court was the claimant's claim presented in time. And there's then a review of what he'd put in his ET1, and at paragraph 8 on 1083, and you can see the complaint is said to be, paragraph 8, the failure to provide a pension for the earlier service, that is to say the pre-PTWR transposition, PTWD transposition date. Nine. That being the case, the next question for the tribunal is when that matter complained of took place. From the details set out on the claim form, the agreed facts which have been found, evidence, it's clear that the claimant dates the action by the respondent, of which he complains, as the day following his retirement, or which he doesn't concede at the very earliest when he got the provisional statement. Having regard to those circumstances as revealed by the evidence, the tribunal finds that the act complained of took place on the 16th of October, the date on which, following the retirement, they didn't pay him a pension. And it's agreed that it's continued from that date. The respondent's case, at 16 through to 18, the respondent, Miss Moore, has made a number of submissions in relation to whether the claimant's claim has been presented in time. It's the respondent's case that the last day that Mr. Wright could have presented his claim was the 14th of March 2001, being 3 months after he ceased being a fee-paid immigration adjudicator. The claim was not, in fact, presented until 2007, 6.5 years out of time. Well, then there's a discussion of the competing arguments and the relevance of O'Brien. And in 22, the tribunal held that the tribunal returns to its findings set out above. The characterization of the claimant's complaint is that it relates to the act of the respondent on the 16th of October. That's the date on which the respondent allegedly failed to treat an earlier period of service as pensionable, and failure to treat any such period as pensionable and subjected the claimant to detriment. Any other characterization would be remarkable, given that even as late as the 23rd of August, when the respondent provided the claimant with a statement as to his potential entitlement, the respondent's own description of the information being furnished was that it was provisional. Now, there's some further discussion later on because there is a question about what if in the alternative a secondary time limit might arise, and that's under the heading Further Matters. And you will see at 27, only if time began to run from a date earlier than the 22nd of August would the claim form have been presented out of time. Various possibilities might be considered, although Miss Moore, for the respondent, that's the MOJ, only contended for the 14th of December 2000, or at least the following day. If one's to apply the putative knowledge of future rights approach urged by Miss Moore, which is a rather elegant way of putting the point that I've made earlier, in the course of her oral exchanges with the tribunal, one might consider, inter alia, the possibility of the 3rd of March 1992, first letter of appointment, and then he goes through all the different alternatives, which I don't read to you. 28. Some of those possibilities might be described with some justification as wholly ridiculous, although it should be borne in mind that in answer to a question put by the employment judge during the course of oral exchanges, the respondent appeared to be suggesting that the proper course of action on the claimant's part should have been to launch proceedings in late 2000 or early 2001 on the basis of hypothetical computation figures, without any indication of whether the claimant might survive long enough to draw a pension at age 70, because it was a 70 rule in immigration judges, with no idea of what the relevant reference level of salary might be at any future date, and with a view to obtaining a declaration from employment tribunal as a matter of general principle, in unquantified terms, as to a possible potential benefit which might be enjoyed by the claimant at some unspecified date. 35 is helpful too. The tribunal views the apparent proposition, this is on 1088, to what should have been the proper course of action to have been taken by the claimant, as so remarkably unrealistic and unattractive as to influence the tribunal in the direction of holding that in all the circumstances of the case, it would have been just and equitable for the tribunal to consider the claimant's complaint, notwithstanding it had been presented out of time. Now, that's the alternative conclusion that it reached. But you can see the force of the points that we've been seeking to make, much more elegantly put by Professor Neal in that judgment. Essentially, the points 2 through to 5 are going to be dealt with in a moment when I open the jurisprudence, which I'll call the 10-over line of cases. But I'll keep going if I may. 6. In any event, the Court of Justice has already ruled, contrary to its universal application, without qualification or reference to 10-over, in cases concerning the assessment of pension entitlements, that unless otherwise justified, there must be equal treatment of periods of working time that took place prior to the relevant anti-discrimination law. The two cases are Felber and Lissar. They're both dealt with in our case. I'll open Lissar shortly in a moment to you, but both of the cases are concerned with Directive 2000/78, which prohibits age discrimination in relation to employment and working conditions. Both of them were concerned with pensions. Both of them were concerned with a failure in a pension scheme to take into account periods of service prior to the transposition date of Directive 2000/78. And in both of them, the court made no reference at all to the so-called universal rule upon which the Court of Appeal founded and which is central to the argument for the Ministry of Justice. Now, it's a negative point. I fully appreciate that Mr. Kavanagh, when he's on his feet, can say to you, but if the state didn't take the point, it wasn't open to the court to do it. So I don't say it's dispositive, but what I certainly say is it's an extremely important straw in the wind. In fact, it feels from this side of the court as being rather like a bale of straw in the wind, because one would expect the court to say of its own motion that the case was out of scope of the directive if there was a complaint about that earlier period of service. The court is always, in my experience, certainly acute to note that it doesn't determine questions which are out of scope. I'll pick that up, if I may, when I've gone through the other jurisprudence, but I'll keep going. Moreover, there are clear examples in which the court has declined to apply the turnover approach, the universal approach, more widely than the context for which it was developed. Now, there are two cases which are important here. One is Maruco, which I shall open shortly. Mr. Chamberlain, who follows in due course on the Walker appeal, will develop Walker and Maruco and indeed Roma at greater length. And I'm not going to discuss Roma and tread on his patch, but I do want to show you the question in Maruco. But more importantly, perhaps, because more specifically, in Paris, the Advocate General precisely rejected the submission that the rule had universal application. Three of the justices of this court will recall that they had the Advocate General's opinion in Paris deployed to them when we had the oral application for permission to appeal. And so we will go through that in a moment. It was discussed at some length, and indeed, I'll pick that point up a little bit later on in a second. So we come back to the FEP, and we note again that by contrast, the CJEU has held in general terms that it applies generally to the application of the Part-Time Workers Directive in our case, in O'Brien and in Bruno, and in each of them held that the Part-Time Workers Directive contains within it no derogation from the FEP rule. And we therefore say that the proper approach to legal certainty for this court is to say that the FEP rule has been determined by the Court of Justice to apply to the Part-Time Workers Directive without derogation, and therefore to apply it consistently with our submissions. We've surmised that at least one reason for the grant of PTA in this case, and in Walker, which didn't have an oral application, but you granted permission in in all three cases at the same time, was Advocate General Cocotte's opinion in Paris. The original listing direction was intended that the court would not hear the case until the judgment in Paris. Regrettably, the judgment doesn't deal with that part of the argument. And that's why we recognise that this is exactly the class of case in which you might be thinking about a reference. And those are the last points that we make there at the end of the thing. So,
when you say we might be thinking of it, does that mean that we have, in your submission, an option?
My Lord, I say that on our case, the FEP is dispositive of the issue. I recognise that there is this body of law in which the application has been fixed from Barber and through turnover. The question for this court is whether it's proper for it to determine whether that jurisprudence is entirely confined to turnover and Barber. Now, we say that it is, for the reasons which I've shown, but what I cannot do is say that there's a judgment of the Court of Justice which says it is so confined. So I take the realistic approach. I've lost this case twice below. Maybe my advocacy was too poor, I didn't deploy all the points sufficiently forcefully, but I do recognise that this has not been finally disposed of. And I've concluded by recognising also from a passage in Rheinmühlen. I don't know how often you now get Rheinmühlen deployed to you on reference points, but it's an important passage which you will well understand the principle that the court ought to make a reference, particularly when its interpretation might affect the way other member states have to apply the part-time workers directive or whatever. So that's the passage in the box in paragraph 30. My Lord, to answer your question in very short terms, I'd be delighted if you held for me without a reference.
Well, much as we like to bring delight to you, Mr. Allen, that may not be the...
That's not the object of the exercise.
But I think I have to follow through the logic of the submissions that we've made earlier, and I have to accept it's not been finally determined, because the closest we get to it is the Advocate General's opinion in Paris, and the judgment simply didn't deal with it. So I have to accept that, and therefore it would be wrong for me, I think, to argue that you can assume silence on behalf of the court signified acceptance. I can't, I think, in honesty, do that. And that's why we take the line that we do. In short, it's a reluctance agreement that this is a case where you ought to make a reference.
Yes, I mean, it's very unfortunate because I think one of the factors in our mind was very much that if we were going to get a definitive judgment from the European Court in the Paris case, it would be sensible to wait for that. But of course, that's disappointed us all.
It did. Absolutely did. I mean, that's not in any sense criticism of you, because everybody, I mean, clearly Mr. Koppel, making the intervention for the Secretary of State in Paris, hoped for that outcome as much as we did, albeit we were arguing or hoping for different conclusions, but we'd certainly hope that would happen. So that's why we've put it in the way that we have. Now, lots of points are made in the respondent's case, tackling the submissions that we've made, but the core of it really comes down to it. They can't point to a case such as this, outside a Barber context, in which this universal rule has been applied dispositively. If they could, they would have done it below or in their case, but they don't.
I mean, do I detect from the way you put it that there may even be agreement now among counsel that there's really got to be a reference? Or?
No, Mr. Kavanagh says it's all act clear.
Mr. Kavanagh says it's all act clear, but my Lord,
wishful thinking.
There is. I mean, let me answer your question in a different way, but precisely. On the judgment of Paris being given, we wrote expressly, saying in an open letter, saying agree a reference, and we were told no. And so, in one sense, when I sit down, I'm hoping I shall have persuaded you that the tricky questions that you're going to ask Mr. Kavanagh is, come on, tell us, after the Advocate General's opinion in Paris, Advocate General Cocotte, why it is that this isn't a reference point. But that's how I hope I shall persuade you in due course. But we shall see. Now, I've got to make good those submissions that I've set out under the cross-heading from paragraph 23, and that means opening some of the case law to you and explaining some of that in some greater detail. And I hope that the submissions to the point have not been too breathless in getting there. My lady and my lords, you will find that there's this document, a colourful document on the bench, which may be of some assistance to you. And it sets out in tabular form, I think, all the relevant cases on the turnover/Barber/ maybe it's not reached quite.
The little document has not yet reached us.
Well, it's coming very soon. I'm so sorry, I thought I'd be more efficient. There we go. Great. But you've got it. Right. I don't intend to open all these cases to you, but they're there in this tabular form, which will help you to absorb the jurisprudence. Just running an eye down, I don't intend to open Defren 1 or Defren 2. Defren 2 is the case, of course, that determined that Article 119 could be enforced by non-state parties, one against another. Bilker, we may mention very shortly, it's the case that determined that it was unlawful and discriminatory to have a rule which made it more difficult for part-time workers to have access to a pension. Barber, we will look at. Verhoeven is a social security case that came immediately after Barber, and we'll look shortly at that. Then you'll see that Turnover, Moroni, Neath, and Collerole are all cases which had the same, I think the same oral hearing date, but certainly the same judge rapporteur, Judge Mancini. The Advocate General's opinion is a consolidated opinion, and it's Advocate General Van Gerven who'd given the opinion in Barber and therefore knew what Barber was all about. The judgments of the court are not all given on the same dates. You'll note that Collerole, Byrne, and Vroger all had judgments on the same date, although their hearing dates and the opinions are on different dates. Advocate General Van Gerven gave 2, and our Advocate General Francis Jacobs gave 1. Megorian is another a part-time workers case on pensions, which we shall open shortly. Preston is another part-time workers case. Barch is not. Barch is interesting for a quite different point, but we will open it because it goes to deal with the fixed issue. And then Brewer, which I think has been added in manuscript, we may or may not open according to the amount of time that is available at the time. But the references down the right-hand column will enable you to get your way through it pretty quickly. I want, if I may, I think, to start with Barber, hoping that it's not necessary to go back to Bilker. And Barber, conveniently, is at tab 1 in volume 1 at MS 10. I will read shortly the headnote to you, although I will take it fairly quickly. Essentially, there was a pension scheme, and the pension was deferred for a man until the age of 62 and a woman until the age of 57. So, on the assumption that women live longer mostly than men, they had quite a substantially greater pension entitlement than men would. Number of employees were being made redundant. The severance terms agreed provided for an immediate pension if the employee made redundant was a man aged 55 or a woman aged 50. The employee compulsorily made redundant at the age of 52 and therefore was only entitled to a deferred pension under the scheme. In short, he wouldn't get it until he was 62, 10 years later. And he complained that a woman of a similar age would have an immediate pension and that he therefore suffered unlawful discrimination. And then he referred to the Sex Discrimination Act and to both the Equal Treatment Directive, as it then was, Council Directive 76/207, and the principle of equal pay for work of equal value, Article 119. And I jump ahead, held that pay in the second paragraph of Article 119 included essentially pension payments. You might want to note also that it was held that a redundancy payment, because it was argued at one point that this was more akin to a redundancy payment than a pension payment, were in ordinary circumstances within 119(2). 2, that although social security schemes or benefits governed by legislation without any agreement within the undertaking which are compulsorily applicable to general categories of workers did not come within Article 119 of the treaty, a private occupational scheme which resulted from an agreement between employees and employers by unilateral decision of the employer was, and that Article 119 of the treaty prohibited discrimination as regards pay, and it was for national courts to safeguard the rights which Article 119 of the treaty conferred. So those are the outline holdings. We can go straight forward to the judgment, which begins at page 59, MS 59, internal 665. And we don't need to read that, but pick it up at 61. This is is it within the Article 119 or the pay directive? And you can see that the court discusses that, and then it deals with the redundancy point at 17 through to 18, which again, I don't need to deal with you at any greater length. And then in 21, the answer is given to the first question. The second question must be understood as seeking in substance to ascertain whether a retirement pension paid under a contracted out private occupational scheme falls within the scope, in particular where that pension is awarded in connection with compulsory redundancy. And it concluded, following Bilker, at paragraph 27 in paragraph 28, that it did. And then you can see the third through to the fifth questions, and I think I can skip over those and the fourth question and pick up at 40, because that's the passage that I shall have to read to you at some length. In its written and oral observations, the Commission has referred to the possibility of the Court of restricting the effect of this judgment ratione temporis for the purpose of the second paragraph of Article 1.9, being interpreted in such ways to cover pensions paid by contracted out private occupational schemes so as to make it possible to rely on this judgment only in proceedings already pending before the National Court. And then you note the next bit. For its part, the UK emphasised at the hearing the serious financial consequences of such an interpretation. The number of workers affiliated to contracted out schemes is very large in the UK, and the scheme in question frequently derogate from the principle of equality between men and women, in particular providing for different pensionable ages. I can skip over 41 to 42. With regard to this case, it must be pointed out that Article 7.1 of the Social Security Directive, 79/7, on the progressive implementation of equal treatment, I don't need to read all that, authorised member states to defer the compulsory implementation of the principle of equal treatment with regard to the determination of pensionable age for the purpose of granting old age pensions and the possible consequences thereof for other benefits. So there was a sub-treaty piece of legislation saying it's okay the pension fund can do what it is doing. And that was then incorporated in a later Social Security Directive, 86/378. 43, in the light of those provisions, the Member States and the parties concerned were reasonably entitled to consider Article 119 did not apply to pensions paid under contracted out schemes, and the derogations from the principle of equality between men and women were still permitted in that sphere. In those circumstances, overriding considerations of legal certainty, and this is the key passage for the turnover jurisprudence, preclude legal situations which have exhausted all their effects in the past from being called in question where that might upset retroactively the financial balance of many contracted out pension schemes. So in short, in 44, the court, recognising what the UK had said, recognising the sub-statutory legislation contrary to what its interpretation of Article 119 was, had said it's okay to discriminate in pension ages, held that it was a question of legal certainty for the future to make sure that the financial balance of those contracted out pension schemes was not upset. Then the next part of that paragraph says, but that doesn't apply to people who have already commenced proceedings. And then 45 gives rise to the provision which led to the so-called temporal limitation. And the operative part it has that in paragraph 5 on the next page. So the question that arose immediately after that is, what on earth does the court mean in paragraph 44? There were a range of options. You can see that it was thought somewhat scandalous to suggest that Article 119 did not apply fully except to those workers essentially who started work from the date of the Barber judgment, because that would mean that equal treatment in matters of pensions might not be fully in place for another 40 years, for a generation. Alternatively, the counter-argument was, we don't want financial institutions to fall over by imposing on them obligations deriving from work that had taken place prior to this judgment. So there were a range of options and a range of arguments as to how that might be construed. There were two really important legal articles that dealt with this issue, and you'll see that Advocate General Van Gerven picked them up and referred to them. I'm so sorry, my lord.
Can I just ask a question before we leave this case?
Yes, of course.
Are we concerned with Article 119 in the present case?
No. No, it's the powers to make the Part-Time Workers Directive derive from the social chapter of the treaty, but not from Article 119.
Yes.
Am I right, Mr. Allen, that in the Court of Appeal, Lord Justice Lewison in particular, treated Barber as a similar but different proposition from the turnover line, on the basis that this was effectively a decision that a ruling of the court should have prospective effect, whereas the others...
Well, there was a lot of discussion about this, and
well, all I'm asking is, have I got that right? He made that distinction.
Lord, yes, I think you do.
And you, I think, by the sound of it, simply say that that's a false distinction.
I do.
Right.
And what it's a key part of our submissions that it's muddled jurisprudence to look at temporal limitations, the power of the European Court, essentially to suspend the application of European law for sound and reasons according to its jurisprudence. It's muddled thinking to say that that is equivalent to the way in which the future effects principle works. It's not the same thing. The future effects principle is a general principle for the interpretation of European law as to how new legal rules apply to ongoing situations, in short.
Yeah.
It's a different thing. And there was much discussion about this. I don't have a lot of time to go through it beyond what I have just said in response to your question.
No, you've answered the question.
But it is a confusion. And the point that led into that discussion was that it was said that the premise for the temporal limitation in the judgment in Barber is legal certainty, as indeed it was. But it's a different kind of problem of legal certainty to the one that confronts us. This is a case which you might equate in domestic law to a legitimate expectation case, where a public authority says, we're going to do X, but then it turns out that what they say they're going to do is unlawful, but everybody's acted on the supposition that they were entitled to say lawfully that they would do X, and then you have to unpick what happens in consequence of that. But our submission is that all juridical systems have to work out how consistently new rules apply to situations. They have to have a rule on that. Now, we might go to the volume on statutory interpretation. We can have arguments about it on our domestic law, but the rule that applies in Europe is the future effects principle, as set out by Advocate General Cosmas, as applied in Bruno and Bettini, as applied, indeed, in O'Brien. And legal certainty itself, in applying European law, depends on upholding the future effects principle. Because that's how other member states and other European jurists will look at new rules. They will say, the future effects principle, does it apply or does it not apply? The answer is the jurisprudence says it does apply without derogation to the Part-Time Workers Directive. We therefore got to work out what it means. Now, my Lord, that's a long answer to your question, but I hope that it makes at least sense, whether you agree with it or not, and it's consistent with what we've said. So there's Barber. Barber says, legitimate expectation, financial disaster if we don't impose some sort of limitation. And that led, as I say, to quite a lot of discussion by jurists as to what the implications of that were. There are two articles which I want to open very shortly to you, which are, we know, were really important for the court in due course, because Advocate General Van Gerven in the turnover cited them. They're by Professor Curtin, who may be known to some of you. She was an advisor to the European Committee of the House of Lords at one point, and by Professors Shaw and Honeyball. And
Professor Shaw is known
Also
to
known
me.
to us.
Professor Shaw is known to you as well.
Professor
But I'm not
Curtin.
at all surprised.
None of this bench sat on the European Committee of the House of Lords.
No, Lord Mance did, I think, if I recall.
Chair.
Professor Curtin's article is at volume 7, tab 96. I'll give you the number in a moment. I'm afraid for some reason I haven't written it down here.
2162.
I'm most grateful to you. Thank you. This is a general article about... No, I'm sorry, I've given you the wrong... that's the one before that. It's 2162. You're quite right. It's tab 96. And it's an article about the constitutional structure of the Union under the lovely title of Europe of Bits and Pieces. And at 2195, under the cross-heading The Barber Protocol, she discusses this situation at some length. Rather nicely picking up, actually, on Lord Hughes' question to me, finally, an argument can be made that Protocol number 2 on Article 119, the so-called Barber Protocol, which was part of the Maastricht Treaty, marks an explicit derogation from the acquis in a manner which is not in any way limited geographically. This was the other unprecedented protocol to emerge by stealth from the Trojan horse at Maastricht, and it provides. It's in your bundle as well. This time, the special interest group was the powerful and wealthy pension funds lobby in the UK and the Netherlands, who were spurred into action by the potentially considerable financial consequences for those two countries in particular, of the Court of Justice's judgment some 18 months earlier in Barber. In particular, advantage was taken of what was propagated as the ambiguity of the court's limitation of the retroactive effect of its ruling on the applicability of 119 to contracted out schemes. At the risk of oversimplification, the field can be roughly divided between those who maintain that the court explicitly and clearly stated that all pension payments paid out after the 17th of May had to be equalised, extreme provision, and those who argued that the court had meant to restrict the benefit of the principle of equal treatment only to those employees who paid pension contributions for periods of employment subsequent to the 17th of May, the date of the court's judgment in Barber. This is a very thorny problem indeed, and one which has not only been the subject of much public debate, resulted in no fewer than 4 references from national courts, and those we're going to go through in a moment. By the unprecedented technique of a protocol purporting to interpret the meaning of an existing EC treaty article, the member states try to present the matter to the Court of Justice in terms of a fait accompli. There was no public debate and no presentation of the alternative prior to the annexation of the protocol. The protocol was included quite irrespective of what the court itself actually meant in its judgment and is considered by some as a warning to the court. The vital question is, of course, how the court will respond in the cases already pending before it and relating also to the critical period before the protocol enters into force, if it does. In any event, it seems clear that the consolidation of the communities is based on the rule of law was subjected de facto to collective political opposition by the arbitrary and ad hoc use made of the technique of protocols annexed to the EC treaty. I think that will draw a wry smile from all of us as we read that. The Honeyball and Shaw article follows immediately afterwards, and the discussion of that is at 2222 MS and 42s, 5 possible interpretations of the Court of Justice's reasoning set out. Equality applies only to pensions for which all contributions are made after May the 17th, may be delayed some 40 years. Applies to pensions for which entitlement is gained after May the 17th, but only in respect of contributions made after the 17th. To protect pension funds against claims which exhaust their resources, as in 2, equality applies in respect to the whole pension period, even though the contributions made will have been affected by the belief that they were not subject to an equality principle. 4 and 5, as in the 2 alternatives in 2 and 3, but extending also to cover pensions which become payable after the 17th of May, although the beneficiary may already have left work, deferred pensions. And I don't need to read, but I hope you will in due course, the next paragraph. But in the last paragraph, the problem with many of these limitations is that they create gross inequalities between what most people who've simply grudgingly accepted the sex-based inequalities in pensions will receive, and those, like Mr. Barber, who've instituted proceedings, as it were, on behalf of the rest of us. And he, like Mr. Clark in an earlier case, has the benefit of an exception which presumably means that his entitlement to an equal pension is backdated to the beginning of his contribution period, even although that may predate the United Kingdom accession to the European Communities, when Article 119 became part of the United Kingdom legal system. Now, that's an interesting coda to his analysis, because it seems that their analysis, both Professors Shaw and Honeyball think that certainly at the time that they were writing, there was no universal rule of the kind that was suggested in the turnover legislation. Otherwise, they would not have read that at all. So there it is. Those were 2 important articles which framed the range of debate. And that then had to be resolved in the turnover cases, which in my chart you can see were subject to the collective opinion of Advocate General Van Gerven. And one gets most of the reasoning implicit in the judgments, because the judgments are short, from that. Can I now start with turnover and the Advocate General's opinion? It's Bundle 2, tab 13, MS 426. And it's quite helpful, I think, to go and just very quickly visit the judgment, because the judgment is very short before we look at the detail of the reasoning. You can just, as it were, feel the width of the case by seeing that it starts at MS 426 and concludes at MS 489, so that's some 63 pages, but the judgment itself covers less than 10 of those, and it starts at 486. The reference in paragraph 1, the proceedings are between the survivor, Mr. Tenhover, who was the widow of a woman who has a different surname, and I forget what it was now, who was a member of the Cleaners Pension Fund in Holland. And 4, following the death of his wife, the plaintiff requested the grant of a widower's pension, refused by the pension fund. The grant was not provided for in the rules of the scheme at the time when the plaintiff's wife died. In reply to an argument the plaintiff based on Barber, to the effect that he requested was to be treated as pay within Article 119, and no discrimination between men and women was therefore permissible. I pause there to say widowers were entitled to pensions on surviving their husband's membership of the pension scheme. So
widows were entitled.
Widows were.
But widowers were not.
Weren't. Yes. I'm getting my errs mixed up. Reference, as you can see, I don't need to read you through that. And then I go to the second question, which is at 15, and you can see how it's dealt with in very short terms. The second question asks the court to state the precise scope of the limitation of the effects in time in Barber. The precise context in which that limitation was imposed was that of benefits, in particular pensions, provided for by private occupational schemes treated as pay. The court's ruling took account of the fact that it's a characteristic of that form of pay that there is a time lag between the accrual of entitlement to the pension, which occurs gradually throughout the employee's working life, and its actual payment, which is deferred until a particular age. Now, that's, of course, absolutely trite in these cases, but it's not determinative. What was determinative is 18. The court also took into consideration the way in which occupational pension funds are financed, and thus of the accounting links existing in each individual case between the periodic contributions and the future amounts to be paid. Given the reasons explained in Barber at 44 for limiting its effects in time, it must be made clear that equality of treatment in the matter of occupational pensions may be claimed only in relation to benefits payable in respect of periods of employment subsequent to the 17th of May, the date of the judgment in Barber, subject to the exception in favour of workers or those claiming under them who have before that date initiated legal proceedings or raised an equivalent claim under the applicable national law. And then the answer is given in paragraph 20. Now, we submit that judgment does not establish any universal rule at all. What it does is it simply says, come on, we've got to recognise these pension funds are funded as the work goes through. And if we don't recognise that, and therefore allow our judgment in Barber to apply to pension schemes where all the work has taken place prior to the judgment, at the point of the legitimate expectation, these pension funds are going to fall over. They won't work. In short, a perfect judgment of that kind would be the enemy of the good, because the pension funds wouldn't pay any pensions to anyone without going through an insolvency process. So one can see, very short form, obvious logic. But what we certainly say is you don't find a universal rule in that judgment. What you find is plain accounting financial logic, that we had to follow through the reasoning that we'd applied in Barber to reach a conclusion that only periods of employment which took place after the Barber judgment are subject to the non-discrimination rule. That's the effect of the temporal limitation.
It's pragmatism rather than logic, isn't it?
So, sorry?
Pragmatism rather than logic.
Well,
Well, I wonder if that's perhaps a fair way of putting it. I mean, the court is clearly in Barber applying the EU principle of legal certainty, a general principle of EU law, and it's explaining here that that's engaged because the pension fund has calculated the contributions made over time on the footing that they had to pay for the future amounts that were then anticipated.
yes, that's it. It's just following through the legitimate expectation point. It really is.
But why isn't it a universal rule arrived at because of that consideration, however pragmatic it may be?
But, my lord, our submission is not that there is no rule. It is that there is a rule that applies in the context of the situations which Barber was contemplating. It applies in the context of the precise situations that Barber was addressing, which was where there was a legitimate expectation.
I see.
That's what we absolutely accept. But to take that rule and to apply it to every situation in which equal treatment in relation to pensions arises is to push it too far. There is no legitimate expectation that's been argued in our case. It's not said in our case that we've been deluded into thinking that we didn't need to approach this in this way. It is certainly true, and I accept this entirely, that the Part-Time Workers Directive didn't have to be transposed into domestic law until April, but what we say is the effect of that transposition is governed by the FEP rule, because that is a constant and universal rule of European law. Yes, and sorry, is that 19? Back in the edges. Yes. I took you to the judgment because, of course, the judgment is what determines the outcome. The reasoning for this is set out at great length in the AG's opinion, which I must take you through as well, so that you can see how that operates. And the relevant passages, noting that this is an opinion that covers all the cases as noted in that chart that I've given to you, starts at page 448, internal numbering 96. The key question in these cases concerns the precise operation in time of the judgment in Barber. It's clear from the observations submitted to the court that the practical importance is enormous. I propose to focus at once on the core of the problem, and there are some 4 possible interpretations of the limitation which the court sought to place on the operation in time of its judgment in Barber. Now, I can take this fairly quickly because these essentially replicate what Shaw and Honeyball had already identified, and indeed there's a reference to this a little bit later on. So, first interpretation is only from the 17th of May, almost deprived Barber of almost all retro.
Well, becoming members of.
Exactly.
That's the important point, isn't it?
Exactly so.
Starting.
And then the second interpretation is periods of service. So one is slightly higher. It's because it may be a situation in which you've not actually made any contributions to 2. 2 is periods of service. Over the page at A, 3 is pensions payable. 4, interpretation to apply equal treatment to all pension payments made after, and then these interpretations he refers to the Curtin and Honeyball and Shaw articles. And the arguments focused on the 2nd and 4th, and you can note that he was well aware of the Maastricht Protocol in paragraph 12. I don't need to read it out to you again. In fact, he refers to that a little bit later on in his judgment. And then you can see he goes through the case law of the Court of Justice on the temporal effects of judgments. I don't need to read all of that to you, but what he does say, and it's really interesting, in resolving this issue, he starts at paragraph 13 by saying, there is fixed jurisprudence on when judgments can be limited ratione temporis. And at 14, to pick up on Lord Reed's point, it appears from that passage that in deciding to limit the scope of a judgment in time, the court is guided by a general principle of legal certainty inherent in the community legal order and a concern to prevent serious problems. And of course, both of those were in play here. And then you can see between F and G, in essence, the court is prepared on account of special circumstances to avoid calling on question legal relationships established in the past, notwithstanding the fact that there are grounds for that under a clarifying ruling which the court has given in the meantime. And
but
then
it says legitimate expectation, doesn't it?
Exactly. And then we can go straight on to C at 101, that the court noted that the financial balance of many contracted out pension schemes might be upset retroactively, and that leads to his passage in 17 when he seeks to resolve these matters. And he starts inevitably on looking at the funding of occupational pension schemes. And nobody's suggesting he gets that wrong. We know how they work. I don't need to go through it. Between D and E, from the legal point of view, this accruing nature of occupational pension schemes leads to a distinction between the coming into being of pension rights, namely as a result of the accrual of the pension on the basis of completed periods of service, and those rights becoming exercisable, namely when the pension falls to be paid for the first time. Now, I'll pause there for a second. He says pension rights begin to exist when you do the work, but he's not saying that they're finally determined at the point you do the work, quite the contrary. He's saying that they're only finally determined at the point that the rights become fully exercisable. And then over the page 19, the distinction between the accrual, or the coming into being of pension rights, and the pensions falling to be paid for the first time, or the pension rights becoming exercisable, to be important for a proper understanding of what the court means in Barber, where it holds that legal situations which have exhausted all their effects in the past may not be called into question. To give that passage a literal reading, as do certain parties in Collarol, is quite wrong. On a literal reading, it may indeed be asserted that the effects of an occupational pension are only fully exhausted once the pension has been paid in full to the retired employee. Such a reading would mean that the temporal limitation of the judgment decided on by the court would have almost no significance, and that the useful effect of the limitation imposed by the court would largely vanish. That judgments of the court may not be interpreted in a way which deprives them of their useful effect was confirmed in Penner, see Advocate General Lenz, in which he cites the case law from which it's clear that a teleological interpretation of judgments of the court is usual. So that's really it. We've got to make sense of what the court was trying to do in Barber. They didn't want financial institutions to fall over, and it's obvious why they wouldn't want to do that, because the gain of equality would be at the expense of insolvency. They didn't want that to happen, and they weren't going to let it happen by an interpretation in the turnover judgment, which is accepted was the literal reading. Here again, the distinction between the accrual and the falling due of the pension helps to clarify matters, since it's the service itself, and in some cases the relevant contributions, which give rise to the rights and obligations of the employer and the employer of the trustees of the pension. It may reasonably be assumed that in using the expression legal situations which have exhausted all their effects in the past, the court had in view situations in which the right to a pension had already been acquired by periods of service. That coming into being of a pension right on the basis of a period of service in the past leads to a legal situation whose effects are exhausted in the sense that the worker has definitively acquired the pension right relating to that period of service. Now, we don't read him, and certainly the judgment doesn't say this, as meaning that the rights are completely definitively for all other purposes. He's saying that interpretation is what is necessary to give a purposive effect to the judgment in Barber. And we can see entirely why that is logical. If you look at the Curtin and Honeyball and Shaw articles, you can see the logic of it. It's perfectly obvious. He wasn't addressing a universal proposition. What he was saying was, how purposively can we resolve the problem in these subsequent cases about the ambiguity of paragraph 44 in the Barber judgment? And
we're dealing with two completely different legal problems, albeit in a similar context. The Barber case was a judgment. Judgments operate retrospectively unless somebody puts an exception in. So they put an exception in for some very good reasons, two reasons really, or interlinked reasons, and this is working out the limits of that exception. We're dealing with legislation here.
that's exactly my point, my lady.
And so what is the rule dealing with legislation? That's what we have to confront, whether these considerations in the pensions context can be carried over to the legislative context, or whether there is in fact a general approach to legislation, which you would say there is, and which gives the answers in your favour. That's where we are, isn't it?
It is exactly where we are, my lady. And as you've seen, my 8 points in the oral submissions essentially try to cover through that. Now, I don't need, I think, to go at great length through all the other judgments, but there is one thing I want to do, because it's helpful to reinforce exactly the analysis my lady's put to me, which is to show the Commission's approach to this. And I make that submission because the role of the Commission in this class of case is very important indeed. Certainly, my knowledge, which is not enormous, but it's certainly reasonably expensive, of the jurisprudence where temporal limitations have been applied in European court cases, is that the Commission submissions are often very telling. The Commission has an overview of how fairness operates between member states and how that might operate. And we've set these out in our case. Again, I'm going to do it pretty quickly, starting at page 2330 in the case. All the references are there. We can do it conveniently with Tenoida, which is already in front of you and open. And if you can pick up at 439C, and in particular H, putting it bluntly, the Commission took the position at letter D on page 440, I mean the passage is all discussed at some length there, non-statutory pension benefits paid to survivors which owe their origin to a contract of employment constitutes pay, and that it's to be interpreted as meaning that the widow of a female worker may, as from the 17th of May 1990, claim such pension benefits on the same conditions as the widow of a male, even if his wife died before that date, without prejudice to the right to rely on Article 119, if before that date there had been legal proceedings. So it was holding that, in this case, the widower could get the full benefit of the years of service of the woman who was the member of the Cleaners Pension Fund. So it took the most beneficial approach.
That was its approach at one stage.
Sorry?
That was its approach at one stage. We're told by the Advocate General on page MS 449 that the Commission
It changed its position.
changed its mind.
And that's what I'm going to show you. That's exactly what I'm going to show you. So it starts at that point, and then we can, if you just go, I don't have time to do all of this, if you can go to my case at 2330, the Commission's position, all the relevant references are there, but I'm going to pick it up in Collerell, which was the fourth and last case to come before the court. Does my Lord Reed have my references there?
Yes.
And then you can see the Commission's radical change of view is in Collerell, which is in Bundle 2 at MS 89. I'm sorry, Volume 1, I beg your pardon, at MS...
Tab 2.
At Tab 2, at 89.
Start at 88.
Oh. I'm told by Miss Krause now to start at 88, so I'm sure that's right.
Just above G.
Yeah.
The Commission admits that it has radically changed its view.
You can see why, in short, what it had by then was the report of financial consultants about the consequences. So, for instance, at 89F, the Commission was nevertheless very concerned about financial and economic consequences, therefore asked the Member States to furnish it with figures and information in that regard, and also asked a firm of consultants to examine the financial consequences. Clear from the information available, the financial and economic consequences of the interpretation of BARBA which the Commission has adopted until now are enormous. When one bears in mind the concern expressed by the Court, the result seems surprising. The Commission has therefore come to the conclusion it can hardly be right. The Court cannot have intended a result which risks bankrupting a number of employers and or pension funds, with consequent negative effects for the economies of the Member States concerned. More likely to be in the Court's intention to limit the effect in time of the Barber judgment in such a way that Article 119 could only be relied on in relation to occupational pensions in situations, all the elements of which were realised on or after the 17th of May 1990. Thus, only pension payments based on contributions made after that date would be equalised. And that was the submission. Can I ask the Court for its notes to read, in fact, all of 89 and 90, and in particular, it notes that this is not the textual interpretation of Barber. You can see that between F and G. And the passage, in fact, continues all the way through, in which, at later stages, the Judge-Rapporteur deals with the concerns of other member states. But that's the key passage, those 2 pages of the Commission. And we say it's perfectly obvious that if the Commission has produced, because it thinks it's necessary, financial reports which evidence the need for this particular interpretation of the judgment, it would be very unlikely that the Court would not follow through on that. The judgment in Collerell is as short as the judgment on this issue, as the judgment in the earlier case of Tenoiva. And you can see that at page 122 for your notes, but I don't take you through it. So there it is. My lady has summarised the situation, and we say that that makes it perfectly clear that the basis on which the Court, in these cases, the four cases, Tenova, Moroni, Neath, and Corral, reached the conclusion that it did. I'm not, I think, going to take any time at all to open Boyne, Vroger, and Megorian, because I've got other cases that I do need to open. The references are there, and I will make the general submission that you will not find in any of those cases a universal statement of the rule that's been relied on in the Court of Appeal below. Barch is a slightly different case, and it's said to be important from my friend's perspective, but we say it doesn't help this court at all. I'll outline the facts to you shortly and then invite you to open it. Barch was a case about a pension. It was an age discrimination case. The situation in Barch was that there was a rule in a pension fund that a widow's pension, that is to say a survivor's pension, would be paid, but only if the widow was not more than 15 years. Let me start again. The survivor, there was a survivor's pension. The survivor's pension would be paid, but only if the survivor was not more than 15 years younger than the deceased.
I remember that. Can't think what it was aimed at.
Absolutely. It's a tragic case because they obviously had quite a long and happy marriage, as far as one can see from the case report. The argument that was dispositive in that case is very straightforward. It was that the member of the husband, who was the member of the pension fund, had predeceased the date for the transposition of Directive 2000/78. So the widower could not rely on the directive. It tells you nothing about the situation in this case, save for one fact, which I want to show you very shortly. And that is that Tenova was cited for quite separate and different reasons in the course of the case. It's at 1385, MS 1385, volume 4, at tab 58.
(1485) is where it starts.
Is where it starts. The conclusion of the judgment of the court, you can see at the relevant question for the court is at 1411, and the conclusion is at paragraph 25. The answer to the first question must be that the application which the courts of member states must ensure of the prohibition under community law of discrimination on the grounds of age is not mandatory where the allegedly discriminatory treatment contains no link with community law. No such link arises from Article 13 or in circumstances such as the main proceedings from Directive 2000/78 before the time limit allowed to the member state concerned for its transposition has occurred. The Advocate General was Advocate General Sharpston, and she discusses at considerable length whether there is a way of bringing the case within the scope. I said Tenova, I think it's Vroger that was actually referred to. I'm not sure if I've made that right. Certainly, Vroger and Megorian were cited in her opinion at, I'll give you the references in a moment. at footnotes 110, and that's at paragraph AG 116. And if you just look at 1406, the court has consistently taken a strict approach to pension schemes, which is in the present case excludes certain categories of persons as opposed to those which provide different benefits. In particular, it circumscribed the non-retroactive effect of its ruling in Barber so as not to apply to the former type of scheme. The court has also been circumspect in accepting grounds based on actuarial calculations to justify differential treatment. Now, all I need to show you is that Advocate General Eleanor Sharpston well had the Barber jurisprudence in mind in the course of the Barch judgment. The significance of that is that it cannot be said when she gave her opinion in Bruno and Pettini, she was not aware of the Barber jurisprudence.
It would be staggering if she were not.
Exactly. And it's a short forensic point that we make to that effect. So if I go back to our route map through it, I've really dealt with, I think, the points through to Little Roman 5, and I'm now going to pick up the Little Roman 6, the Felber and Lessar cases. I shall do that solely by referring to Lessar, which is MS 194, Volume 1, Tab 5. If you can pick up, there is, I think, only a judgment in this. You can pick up the point at 197 onwards. Essentially, there was a pension rule that said service prior to the age of 18 was not taken into account. And Mr. Lessar, who was born, you can see in paragraph 8, on the 3rd of June 1949, had been an apprentice for a period of time between the 9th of September 1963 and the 8th of March 1967. The court accepted that the pension scheme in question fell to be considered under Directive 2000/78. And it concluded that there was discrimination in excluding, in the calculation of his pension, the period of service between 63 and 67, when he'd been 18. So long before the transposition date of the directive, there was discrimination. However, Directive 2000/87 permits justification of age discrimination, and it examined the justification put forward by the state and concluded that the discrimination was potentially justified. So it's a negative point in one sense that we make. We say, if there was a rule of universal application, that in matters of pension, you disregard periods of service that antedate the new law, the court could have shortly dealt with this case by saying this is entirely out of scope. It's not covered by European law. Lord Reed's frowning at me if I've taken that too quickly.
Well, your point is you didn't need to get into the area of justification.
Didn't need to go anywhere near it. Didn't need to discuss whether it's discrimination or justification. Just simply say, it's history, mate, in short. This case...
They're talking about a change in the legislation or new legislation.
They don't discuss the future effects principle at all.
They don't, but that is what we're talking about.
And it's assumed, in sense, it's absolutely assumed in this case that Directive 2000/78, which came into effect, I think, in Germany, if this was, no, it was an Austrian case, not a German one, it would have come into effect in 2003 in Austria, prior to his retirement. They accept entirely that it applies to discrimination which arises from treatment of earlier periods of service.
Yeah, but was there any argument about whether or not?
No, my lord, and I've made that point quite clearly. I can't push the point so far as to say that it knocks down my friend's point. It simply assumes the future effects principle in the way that we operate it, and we say it should be operated. But that's why I answered your question earlier on, can we avoid a reference? And the answer, I think, is that in fairness, where I stand here, I have to accept that it is simply assumed. There's a second case which is referred to in here, which is Felber. We've cited it in our oral submissions. You've got all the references there. It operated on the same basis, and we say it helps us as well. The only argument that's put forward against us is to suggest that in some way this is about social security, not about work. Well, I don't get that point at all, for the very simple reason that it's perfectly clear that there's a universal application of Directive 2000/78. There it is. That's that point. That's point 6, and that brings us on to Little Roman 7, which I've now got to deal with in the next 7 minutes, and also in relation to Paris. Maruco is at Volume 1, Tab 7, at MS 202.
212.
Sorry, the judgment is at. The judgment's in a is at tab 7. That's right. There are two versions of this. The easiest to deal with is the All England version, which starts at page 251. The question, all the facts of this are better set out in Mr. Chamberlain's case, but the facts of this concern a claim to a survivor's benefit granted under a pension scheme called the VDDB, and whether that was within Directive 2000/78. And the context for this is set out in the Court of Judgment's judgment, which is at 277 and following. And if you'll turn to page 282, all the questions are then parsed at 282. And the first question is whether the complaint is in or out of scope of Directive 2000/78. Now, it's also interesting because, of course, for quite separate reasons, Barber was cited at paragraph 32, so they must have had Barber in mind. And then you'll see the question at paragraph 74 that the court parsed from the fifth question that had been made by the referring court. The referring court seeks to know whether in the event that the court were to rule that Directive 2000/78 precludes legislation such as that at issue in the main proceedings, which prevented same-sex couple survivors from taking the benefit of a pension, entitlement to the page 289, MS 289, entitlement to the survivor's benefit in issue in the main proceedings must be restricted in time. So the court itself actually asks the question generally whether any restriction in time on the application of Directive 2000/78 to survivors' pensions. It's a general question with a specific conjunction, in particular to periods subsequent to the 17th of May. It is true the argument went off on the Barber point. You can see the observations from the pension fund. But it's put generally, your pensions fund says the Directive 2000/78 cannot be given a retroactive effect by means of a decision that the directive applied at a date prior to the date of expiry of the period allowed to member states for its transposition. And then in 77, the court's reply, it's clear from the case law the court may exceptionally, taking account of the serious difficulties, apply a restriction. There's nothing in the documents before the court to suggest that the financial balance of the scheme managed by the pension fund is likely to be retroactively disturbed if the effects of this judgment are not restricted in time. So they hold that there's no restriction in time, whether barber or otherwise, in the application of Directive 2000/78. They had barber in mind. They must have thought about turnover. They don't say it's only limited to periods of service of the principal pension member after the date for transposition. And that leads us to the opinion in Paris, rejecting Mr. Koppel's submission. We've dealt with this comprehensively in our case. Time's run out for me to go through it at any great length, but I do want to just open the case so that I know for sure that the court have also seen it.
You've 5 minutes, Mr. Allen.
I do.
That clock is never right.
That will be fine. I have 5 minutes. I'm grateful to you.
You have 5 minutes. I'm going on the clock on my computer.
Well, then that's extremely kind. I don't know what that means for this court, but I'm very grateful. We deal with this completely in our submissions to the court in the case, and I just invite you to pick up 2333. I shall go through in 2 minutes, and then I shall look at Bruno and Pettini and at O'Brien. You'll see the issue was referred to in paragraph 89. I'm sure you'll have read it already. And essentially, there was a submission from the intervening party, the United Kingdom, written by Mr. Koppel, who's here today, and you can explain what he was up to in that, saying that essentially the point that Mr. Kavanagh is arguing. You'll see that in 101. The UK raises the objection that Dr. Paris's pension entitlements are based almost entirely on periods of service completed prior to the entry into force of Directive 2078, cannot be subject to the principle of equal treatment under that directive. That's the proposition. The objection is unfounded. And then you can see he applies the future effects principle. Settled case law, a new rule of law. I am so sorry, my lady, and I know perfectly well that Advocate General Cocotte is a very, definitely a female member of the court. She says that objection is unfounded, for it is settled case law that a new rule of law applies from the entry into force of the Act introducing it. It doesn't apply to legal situations that have arisen and become definitive under the old law. Does apply to their future effects and to new legal situations. Otherwise subject to the principle of non-retroactive legal acts only if the new rule is accompanied by special provisions which specifically lay down its conditions of temporal application. That's our case on it, essentially. The argument for Mr. Koppel is set out in extenso, and then the reply in extenso from Advocate General Cocotte is at 104 in our case. I don't have time to read it to you, but it's there.
Well, we have already.
And so we conclude by saying she has said the FEP applies to Directive 2078 generally. We have already said and shown you that the FEP applies generally to O'Brien and to in Bruno. The argument to try and divert you from the force of that from my friend is to say Bruno is about a different kind of problem. But that argument completely founders when you look at how the future effects principle is set out in Bruno and indeed in O'Brien. It is set out in general terms, just as the Advocate General has done in Paris, and then specifically applied to the problem that was faced. And it's pointed out that there is no derogation from the principle in the Part-Time Workers Directive, i.e. no temporal limitation on the retroactive effect that the future effects principle has, if that's the right way to describe it. My lady, I hope that I can take it that you will have read what we've said about Bruno and O'Brien in our case, and I don't need to open those. And that concludes, as I say, whistle-stop pace, the submission subject to the notes I'm getting from behind me, if you'll allow me a second. Yes. Mr. O'Brien wants me to remind you of something which I feel confident you're likely to be clear. It isn't for a domestic court, however high it may be, to impose the temporal limitation on the application of European law. I'm sure you're well aware of that. Thank you very much. Can I just ask Mr. Chamberlain that I haven't done anything that he finds difficult? He's smiling. Thank you.
Mr. Allen. Ms. Krasnick?
Nothing, thank you, my lady.
Now, a certain amount of rearrangement is going to be necessary, isn't it?
My lady, in fact,
Oh, no.
not.
Oh, no. I'm misreading my timetable. You come now, Mr. Kavanagh. Yes.
My lady, my lords, we say that the issue in this appeal is Act Clare, and therefore it's for us to show that the EU law concerned has already been interpreted by the court, or that the correct interpretation of European law is so obvious as to leave no room for reasonable doubt. We respectfully submit that both limbs of the Act Clare test apply here. The Court of Appeal certainly thought so, and so did Sir David Keane. I won't have time in my submissions to take you to those judgments, but I know that the court has read them. But if we are right that pensions are deferred pay, the right to which accrues and is permanently fixed at the time of service, then the answer to these appeals we submit is absolutely clear, because Mr. O'Brien has no claim in relation to pension that is attributable to service prior to 2000, 7th of April 2000, and for the purposes of the time limits, Mr. Miller and his fellow claimants, not Mr. Miller anymore, the claimants under the Miller banner, have time that ran from the end of the fee-paid appointment about which complaint is made, not from the date of retirement, final retirement, which was later. In my respectful submission, particularly in light of Mr. Allen's oral submissions, 4 matters are common ground between us, which get us, in my submission, most of the way home. The first is that we are all in agreement that the Part-Time Workers Directive does not have retrospective effect. The second proposition, common ground, is therefore that prior to the 7th of April 2000, it wasn't unlawful to treat part-time workers less favourably in relation to pension than full-time workers. Third, I don't think there's any disagreement between us on the general proposition that pensions are deferred pay. In fact, that's been said by the Court of Justice as long ago as the Bilker-Kaufhaus case. And fourth, and I hope I'm right to say this, but I think I am in light of the way that Mr. Allen puts his case.
He'll tell us if you're wrong.
I'm sure he will. If this were a Barber-style case, he would lose, because Tenova provides the answer, and I think he concedes that in a Barber-style case, the position is that your rights are definitively established whilst your service carries on. And I don't see my learned friend intervening. His point, as I understand it, is that, as the Court of Appeal put it below, Barber is an island, and the case law on the Barber principle doesn't read across to the legislation cases, the future effect principle cases, of which this is an example. We, of course, submit that he is wrong. And what I'm going to do in the first part of my submissions is take you to the case law, which in my submission shows that the same test applies to a legislation case as to a court-made rule case, such as Barber. As my Lady Hale said in a question to my learned friend, there are two contexts in which European law has to work out which rights, what I should say, when rights are definitively established for the purposes of applying European law. The first is when the question is whether the cause of action accrued by the time the law came into force. That is what our case is about, and that is the case the issue that's described as the no retroactivity principle and the future effects principle in the cases and certainly in our arguments. The second type of case is where the court has said that for exceptional reasons, claims cannot be brought in relation to periods prior to the court's judgment, even though the relevant law was in force prior to the court's judgment. And Barber is the paradigm example of that. There are other examples. Defriend number 2 is another example of that. But in both cases, the task is the same. The court has to find out when rights are, to use the language of the Court of Justice and the Advocates General, permanently fixed, definitively established. And for the same reason, because you are trying to see whether the law applies to the facts in the particular case. And the first proposition I wish to advance through the authorities is that the case law sets out the test as being exactly the same in both legislation cases, as I'll call them, and in Barber-type cases, as I'll call them. And the answer is given, as it happens in a Barber case, but the answer is given for our purposes as to how you apply that test to facts like ours by the Tenova judgment and a succession of judgments that have adopted and applied the Tenova approach. So what I'm going to begin, if I may, is by just rattling through a few passages in legislation cases to show the way that the test is defined by the court, and then show you that exactly the same test, indeed exactly the same language to a great extent, was used by the court in Barber itself and in Tenova. And I'll begin, if I may, by showing you a passage from the Ulla-Britt Anderson case, which my learned friend helpfully quotes extensively in his written case. You'll find it at page 2345.
Could you give the volume number as well?
Yeah, this is in the core volume.
This is in from his case.
From his case.
From his case.
Yes, just for convenience. He's read this to you already. It's paragraph 57. And it's Advocate General Cosmos who says, I think it's necessary in this regard to clarify certain points regarding the temporal effects of a rule. First of all, there must be no confusion between the retroactive effect and the immediate effect of the rule. In order to distinguish between them, regard must be had to the temporal aspects of situations governed by the rule. Retroactive effect consists in the application of the rule to situations which were permanently fixed before the rule came into force. And then he goes on. This is the only example I can find of the word permanently fixed being used, but it's plainly the same test as is applied in other cases. And so if I may ask the court to move to Authorities Volume 1, tab 4, at page 188. This is a case we haven't looked at yet. It's a case I fear to pronounce. Pokro Zeptovovits-Meyer from 2002.
Where do we find the beginning of the case?
I beg your pardon, page 168 is the start of the case.
168. Thank you.
This was a case, a classic example of the future effects principle, because it was about race discrimination or nationality discrimination in relation to a contract of employment that had begun before the law came into force, but was still on foot when the law came into force. And the issue was whether the very fact that the contract was already in being, the legal relationship was already established, meant that the EU law didn't apply. And the court, of course, said no, because the whole point of the future effects principle is that a continuing pre-existing legal relationship is governed by the law, provided that the particular aspect of the relationship is not definitively fixed at the time that the law comes into force. The relevant part of the judgment is at paragraphs 46 to 56 on page 188. by its second question, this is the court's judgment, the referring court is asking whether the relevant provision of EU law applies to a fixed-term contract of employment made prior to the date of the Europe's agreement's entry into force, but due to expire after that date. And at paragraph 49, they provide the answer. According to settled case law, in order to ensure observance of the principles of legal certainty and the protection of legitimate expectations, the substantive rules of community law must be interpreted as applying to situations existing before their entry into force, only so insofar as it clearly follows from their terms, their objectives or their general scheme, that such effect must be given to them. That's the straightforward no retrospectivity rule. 50 deals with future effects. It also follows from settled case law that new laws apply immediately to the future effects of a situation which arose under the old rules. And then it goes on to talk about the periods of accession of certain countries, and carries on, it's appropriate, therefore, in order to reply to the second question, to determine whether the situation in which a fixed-term contract was concluded prior to the date of the Europe Agreement's entry into force constitutes a situation arising prior to that agreement. And the answer is given at 52. The conclusion of a fixed-term contract of employment does not exhaust its legal effects on the date of its signature, but, on the contrary, continues regularly to produce its effects throughout the duration of that contract. Therefore, the application of a new rule, such as in issue, from the date of its entry into force to a contract of employment concluded prior to its entry into force, cannot be regarded as affecting a situation arising prior to that date. So the point that I emphasise is the language used in paragraph 52, that the conclusion of the fixed-term contract doesn't exhaust its legal effects. Now, this judgment comes in point of time after Barber, and we'll see that exactly the same words are used in Barber to deal with the Barber-style limitation as opposed to the legislative limitation. It's also significant in my submission that the basis for the no retrospectivity and future effects principle is set out in paragraphs 49 and 50 to be based on legal certainty and the protection of legitimate expectations, because that's the same jurisprudential underpinning as we see when we come to look at the Barber-style limitation. The next three authorities are fortuitously in the same bundle of authorities, which is bundle 5. And the first of those is tab 65, which is page 1520, Centeno Mediavia. It's a case about officials. I don't think the facts are necessary in order to understand the paragraph that I wish to draw to your attention.
Could you give me the reference again, please, John?
Yes, it's volume 5, tab 65, starts at page 1520. I'm interested in page 1530, which is part of the court's judgment. Paragraph 61, the court says that it's well established that amending legislation, such as the regulations amending the staff regulations, applies unless otherwise provided to the future consequences of situations which arose under the previous legislation. That is so except for situations originating and becoming definitive under the previous legislation, which create acquired rights. So again, we're talking, here the language is slightly different, but obviously the principle is exactly the same. Situations becoming definitive and acquired rights. And 2 tabs on, tab 67, is the Freistaat...
Well, perhaps also paragraph 63 is quite useful. Or relevant, anyway.
My Lord, yes. A right is considered to be acquired where the event giving rise to it occurred before the legislative amendment.
Yeah.
Indeed so. Just 2 more examples, if I may. Freistaat Sachsen is tab 67, starts at page 1593, but the relevant paragraph is at 1602. This was a state aid case. Paragraph 53 of the judgment. Again, the question was legislative applicability. Consequently, the notification by a member state of aid or a proposed aid scheme does not give rise to a definitively established legal situation which requires the Commission to rule on their compatibility. So the only point is that this time the language is a definitively established legal situation.
Paragraph?
Paragraph 53, my Lord.
Thank you very much. Got it.
That was a 2009 judgment, so all of these post-date Barber. And the last case on the legislative rule that I'll take you to is the next one in order, tab 68, page 1604, the Moravia gas storage case. This is a recent case decided in March 2015. In this case, it was the same Advocate General as we'll see, was the Advocate General in Paris, Advocate General Cocotte, and at page 1613, paragraph 30, she sets out the test in entirely orthodox way. She says, in summary, it may be deduced from those principles recognised in settled case law that new law is not to apply to definitively established situations, save where otherwise provided by way of exception. By contrast, ongoing cases in which legal situations have not yet arisen and become definitive under the old law must be assessed under the new law as soon as that new law enters into force. And that is echoed in the court's judgment at page 1626, paragraph 32. A new rule of law applies from the entry into force of the Act introducing it, and while it does not apply to legal situations that have arisen and become definitive under the old law, it does apply to their future effects and to new legal situations. So I'm sorry, I may have laboured this point a bit too long, but the test for the statutory, for the legislative limitation, depends upon whether the legal effects have been exhausted, although the language that is used differs slightly from case to case, but in my submission, the particular words perhaps don't matter too much. What is helpful, though, is if one then goes to Barber, which is in volume 1, tab 1, and within that at page 66, this is where the court describes what I've called the Barber principle. It's a misnomer because it's a principle applied before Barber, but the principle that on rare occasions the court will limit the retrospective effect of its judgment. It's paragraph 44. The court says, having referred back to Dufresne and Sabina as an example of this being done, in those circumstances, overriding considerations of legal certainty preclude legal situations which have exhausted all their effects in the past from being called in question, where that might upset retroactively the financial balance of many contracted out pension schemes, unless people have already put a claim in. So the words that have exhausted all their effects are exactly the same words as were used a number of years later in Poker Zeptovitz Meyer. And they're entirely consistent in my submission with the test that is applied in the legislation cases. And then if one turns to Tenova, which unfortunately is in volume 2, at page 455, it's in tab 13. After the short adjournment, I'll come back, as you might anticipate, to Tenova, the glory in the language of the Advocate General's opinion, because in my submission this provides the answer to this case. But for present purposes, can I focus on something that is said in paragraph 19. So it's at the top of page 455. I also consider the distinction between the accrual of the pension or the coming into being of pension rights and the pensions failing to be paid for the first time or the pensions rights becoming exercisable to be important for a proper understanding of what the court means in Barber, para 44, where it holds that legal situations which have exhausted all their effects in the past may not be called in question. To give that passage a literal reading, as do certain parties, is quite wrong. On a literal reading, it may indeed be asserted that the effects of an occupational pension are only fully exhausted once the pension has been paid in full to the retired employee. And in the next paragraph, it's within paragraph 19, the one that begins here again, there is reference again to legal situations which have exhausted all their effects in the past. In fact, it's referred to twice. So in Tenova, the test the court was applying, or test the Advocate General was asking himself, and we'll see in due course that the court applied, was the very same test as is applied to legislation cases such as ours. It so happened that the application of that test in the pensions context arose in a Barber-style case rather than in a legislation-style case. But in my submission, it doesn't follow that one has to be blinkered, if I may put it that way, or one has to treat this Barber rules as an island, as the Court of Appeal so helpfully put it, so as not to apply the same test to a legislation case as one would apply to a Barber case. My lady, I see the time. I don't know if it coincides with your...
Virtually exactly the right time.
Grateful. May I
Anyway, it's
stop?
obviously a convenient moment.
It is, indeed.
We'll look forward to hearing from you again at 2 o'clock. The court is now adjourned.